Good afternoon, everyone. Welcome to this special 1-hour webinar spectacular. Today from Hines Legal, I'm Chris Irons, Strata advisor, former Commissioner for Body Corporate and Community Management. With me today, as always, Frank Higginson from Hines Legal.
Hello, everyone.
Frank. Also joining us today, very warm welcome to Nikki Jovovich from Look Up Strata. Nikki, welcome.
Thank you very much. Hi, everybody.
So really glad to have Nikki on board. So Look Up Strata, for those who don't know, it is a fantastic online resource for Strata right across Australia. And today we're sort of tapping into some of that database to get the message across today about what's been a fairly significant development in Queensland. After literally years of development, we have some new body corporate legislation. What has happened is that new regulation modules have been released. They will not become operational until March 2021. But today, Frank and I are going to go through not every single item, but what we think are some of the big issues. We're going to point out some of the significant changes, not just changes from what is currently, but changes from the drafts that were previously released.
No one has seen before now.
Yeah. And we're going to try and emphasize to you the need for best practice. So just a couple of points, bit of housekeeping before we begin. Please don't forget to like and share. The wider this sort of thing gets out, the better it makes our ability to tailor and structure these events in future. So that's really important. You can ask questions live today. You can ask that by putting a question up on the Facebook chat. We will endeavour to answer as many of those as we can. We might be a bit pressed for time, so please be patient because we have got a reasonable amount of content to get through today. And just a final note, for those of you who are regular watchers who wouldn't be, right? You would know that we've been doing these events on Fridays. Today, we're doing this event on Thursday, number one, because the reg modules came out yesterday, but number two, we are actually moving to Thursday webinars. So today marks the start of our Thursday webinar series, as opposed to our Friday webinar series. I hope everybody's got all of that in mind. It's an hour-long session today. We'll try and get through as much as we can. Nikki is going to leap back in with us towards the end. Nikki, we'll see you in a little bit.
Okay, thank you very much. I'll be sitting in chat, so I'll interact with people that way, and I hope it goes well.
Moderator away.
Outstanding. So look, Frank and I agree that we don't want to spend too much time going over the laborious process of how we've arrived at this point, but we do need to cover a couple of aspects before we get into the nitty-gritty and the detail. Today, we're going to talk about standard module only. So when we make reference to section numbers, it will be standard module. There will be corresponding sections of other modules, but as I'm sure everybody here is aware, there can be a significant difference between what's in the standard and what's in the other modules. Just again, a reminder, effectively, there are 6 months, or 5 if you like, between now and when these regulation modules come into effect. So you have that amount of time to prepare yourself. I reckon that's a double-edged sword, Frank, because on the one hand, 6 months doesn't seem like too long, and you might say to yourself, oh, well, that's good. I can spend that time getting myself up to speed. But what that does mean, though, is come April next year, if you're not ready to roll with your responsibilities, if you're a body corporate manager or a secretary or committee or an owner, you don't really have much of an excuse, do you?
No, and it's a little bit like university. You've got 6 months doing a particular topic, yet you still end up cramming like crazy on the night before the exam. So, it is a matter of getting organised. And for me, this is a lot of process, and dare I say it, it's sort of, a lot of this stuff is not necessarily what you would consider controversial, but there is an administrative overlay that everyone's going to need to get their heads around, because it will change actual day-to-day practice more than anything else, I think. So it's just a matter of getting organised sooner rather than later. And inevitably, not everything is covered. So even as Chris and I have been preparing for this, we've run through things. Some of it's not clear to us. And you go to the explanatory note, and it's not necessarily clear there either in terms of where things were. So there's still going to be some interpretative issues that unfortunately might be decided by adjudicators in the Commissioner's office at some stage once this commences. who knows? I mean,
absolutely. Yeah. And look, the bottom line is this: no matter how many times you read the body corporate legislation in Queensland, there are still what are called silent areas, still ambiguities. That has not changed with any of this. You are still going to have to find your way through with reasonable decision making and best practice, which we will touch upon today. I think the other good point to make here, Frank, is that you and I have been involved in this process for a long, long time,
yes.
wearing a few different hats. So as commissioner, my office, regularly consulted for 5 years, 6 years, literally it's been that long. You've been involved too, Frank.
Yeah, I was wearing a RAMA hat, management rights industry hat, sitting around the table with you as commissioner, and I suppose you're now at the SCA. So it's an interesting process, and there's a lot of background to it as to why some of these changes have been made. And I suppose, one of the questions is now, having seen them, is it going to achieve all the things that people are trying to achieve?
Good question. I mean, and the other point, and not to blow our own trumpet too much, Frank, but really there would be few other people with the kind of overview of these amendments and what they might mean than the two people presenting today, other than the people who drafted them, frankly. And as Frank rightly pointed out to me, they aren't available for commercial opportunities.
Whereas we are. So reach out if needs be, ladies and gentlemen, as we get there. But anyway, into it.
Yeah. So very, very, very quickly, the property law review was commissioned by the former Newman government. Geez, that takes us back, doesn't it? So literally 7 years ago, and they have released many discussion papers and issues papers up until that point. The result that we have today is brand new regulation modules. All of these regulation modules are dated 2020. So come March 2021, they will be in force. There are a number of issues which are not covered under these regulation modules. And it's fair to say, Frank, they're the big ticket issues, aren't they? Pets, smoking, towing, scheme termination, not covered here. They will have to be covered in amendments to the Act. When does that happen? Beats me. It really does depend on what happens at the election, I think. That we are about to move into an election in Queensland. It depends on which government gets back in and what their priorities are. But I should stress, these amendments we're talking about today, they're law, that's not changing, but everything else that was covered in the review, up for grabs at this point. If your comment to Frank and I today is either these new changes are unfair, or why haven't the previous changes been addressed? I want to see some action on smoking. We're not the people to direct that to. The people to direct that to is your local MP or whoever else is sitting for state parliament at this election. Strike while the iron's hot. Now is the time to do it. Frank, anything to
completely agree. There? Completely agree. So, I mean, and that's the thing. I suppose everyone's precedents, templates, etc. We had modules from 97, we had modules from 2008, now we'll have modules from 2020. And the way they do these is they just completely bin the 2008 version, and here is the 2020 version. So there will be some changes, well, there certainly changes terminology, section numbering and everything, but the Act is where the controversial stuff is, which we haven't
seen. There's no time frame on when that is going to be addressed, or how, or even if, for that matter. I also interestingly got a question today before this about whether or not Bugta was being amended. Afraid not. Poor old Bugta sits there by itself. So with that, let's rip into it. We've divvied this up into categories, and we're going to firstly go over changes to committees. So Frank, I might hand over to you on this one. The vexed issue of co-owners, Frank.
It is.
What's happening there?
Absolutely. So what we saw a little bit of, it's bizarre, it didn't happen for ages and then suddenly had a raft of them. So I don't know where the idea came from, but ladies and gentlemen, what you would say is if Chris and I owned a lot together, and we wanted to dominate the committee, what would happen is Chris would nominate for the lot that we owned, and then I would go and find a friendly person, another lot owner, who would appoint me as their nominee for the purposes of committee. So suddenly, Chris and I are sitting on the committee together, despite the fact that we only own one lot. So that in section 11 has been changed so that if there are a minimum of 3, that we can't be on the committee together unless we own more than one lot. So if we own 2 lots, then we could nominate one each, but I can't sort of finagle my way onto committee otherwise. as a single lot owner. So there was a few of those, and I suppose when you get more than one couple doing it together, suddenly that might be 4 people on committee, and that is the majority. So that door has been slammed shut. So I suppose what that's trying to get to is just one person. I suppose, what would you call it? Gerrymander. If you're going to go back to the political days, 1 vote per person.
Yep, definitely. And look, it's an issue that comes up a lot, will continue to come up a lot. Why is that the case? Because the committees are the decision-making executive of a body corporate. And let's be frank about it. No pun intended, but let's be frank about it. That's where the power is, isn't it, Frank?
Yep, absolutely. They guide the owners in general meeting. Their recommendations are given. They control what goes up, by and large, and that can be for good or bad reasons.
Absolutely.
So, yeah, probably
so
trying to corral that a little bit.
So that's section 11 of the new standard module that we're referring to there. Next one is one that I think is actually a bit of a double-edged sword, looks really good on the face of it, but might pose a few issues. And this is about getting a particular number of committee members called from the floor. So Frank, at the moment, we have a situation, don't we, where you have a committee meeting, committee positions are being elected. Once you reach the minimum, which is 3, you can stop. That's it. Happy days. Bit different now, isn't it?
It is. There's going to be an obligation to keep calling for, well, not to keep calling for, but to call for nominations from the floor. So the way it works is there's 7, 3 executive, so chairperson, secretary, treasurer, and 4 ordinary members. So if people nominate before the body corporate's end of financial year and there's no one that nominates against them, they're automatically elected to whatever that position might be. If there's more than 1 nomination, then there's a ballot. So 2 people nominate for chair, away you go. But up until now, there hasn't been an actual obligation, as much as I think practice was a lot of committees body corporate managers would say to people, well, we've only got 3 people. Does anyone else want to chip in? Because between the end of financial year and the AGM is 3 months, usually. So at that stage, people can have changed their mind, can have bought in and want to participate in body corporate decision making. And previously, because they hadn't nominated, they had no right to do that, but that's changing. So if there's not the executive positions, if no one's nominated for chairperson, then from the floor of the meeting, does anyone want to be chairperson? And the same with respect to the ordinary members. So that to try to get 7 people involved.
And so the motivation, I suppose, Frank, isn't it, is to maximise that owner participation in the decision-making process. So one of the fundamental issues with body corporate legislation is actually getting people to participate in their own outcomes. So this is a way of encouraging that. So there might be instances, mightn't there, Frank, where either somebody is relatively new as an owner, or maybe didn't get their nominations in on time, or just maybe they rocked up to the meeting, didn't really have an intent to be on the committee, but somebody started calling for nominations, and you know the tendency, human nature as it is. Oh, okay, you need somebody. Okay, I'll put my hand up. Might as well. Yeah.
And if you've shown enough interest to actually go to the meeting, it probably is reflective of the fact that you might want to get involved.
I think that's right. But the flip side of that, I think, and argue with me if you want, is that too many cooks might spoil the broth, mightn't it?
Possibly. And I mean, it's interesting. I come back to Malcolm Turnbull's autobiography I read a little while ago. Sorry to be political, not political. He was saying one of the difficulties with Parliament is that in business, you pick who you want to be in business with. In Parliament, you get thrust upon you people that are elected for whatever reason, for whatever purpose, and with whatever particular agenda. And I suppose, mate, you've seen it as much as I have in terms of committees, trying to control the type of people that do come on. Boards are the same. It could be interesting, where some people nominate from the floor that weren't otherwise invited. It's like, well, who invited you, mate? Well, the legislation did. Thanks very much.
I think another old adage for this one, Frank, be careful what you wish for. Yes. If you think that you want more people to be on the committee and more participation, that's great. Just be prepared for the challenges in managing 3 or 4 other voices around the committee table. I can guarantee you, as somebody who actually sits on the committee of a non-for-profit myself, it's not an easy task, that one. I see we've got a few questions. Thanks, everyone, for that. We will get to those. Frank and I just want to make a bit of progress with some of these, and we'll come back to that. The next one, this one came as a bit of a surprise, didn't it, Frank?
It did.
Deciding upon owners' motions at a committee meeting.
Yes. So this is one of the ones that I wouldn't call it left field. I mean, there was.
I would.
Yeah, I suppose there was. We saw drafts, gave feedback, saw further little drafts, gave feedback, and now we see the final versions, and this hasn't had any feedback on it at all. So it's interesting when you read it. It's like, oh, it's like Christmas. You open it up under the tree, and here's something really interesting. So, what I suppose come up a level back to rationales. I think where the government's probably trying to get to is actually create an obligation for committees to consider material from owners, because up until now, the way for owners to have their voices heard is to put a motion on the agenda for a general meeting. So if the AGM's only once a year, you get that motion in by the end of financial year. AGM's 3 months of that. That's the one time that you have the chance to have owners, or I suppose everyone in the building, make a decision on your particular point. Up until now, there has been no ability at all to ask a committee to consider something for you. So there's absolutely that overriding statutory obligation to act reasonably, which has always been there, but there's been no sort of, I suppose, statutory support in terms of saying to a committee, you must consider this, and they've changed that. So I suppose where's it got to is that owners now have the ability to submit, I'd say, Chris, up to 6 motions.
That's right.
To a committee over a 12-month period to be voted on or to be decided on, and that must be decided within that. The response to that must be decided within 6 weeks, unless there's reasonable grounds to extend that, in which case the committee must respond and explain that. And they also must respond and explain, if they're refusing these motions, why they did it. And I suppose the other thing that's a little bit interesting, we'll talk about Vox in a minute as well for me, is that it's sort of, there's a deemed refusal. What happens in bodies corporates is apathy. We know that it happens at general meeting, people don't show up, they only get upset about their particular issue and whatever it might be. With this, what's being created is effectively a deemed refusal. So if a committee doesn't respond within that 6 week, and effectively it extends it out to a 12-week period. So if a committee doesn't respond to a motion within those 12 weeks, they've deemed to have said no to it.
And that's important, isn't it, Frank? Because
it is.
At that point, the deemed refusal is the trigger for a dispute resolution process.
Absolutely.
So one of the issues that always happens in the Commissioner's office is that you've got situations where people would call in and they'd say, well, I've had my request for approval in for months, and there's been radio silence all that time. It's difficult to dispute the fact that you haven't had an answer. But now, under these provisions, a non-responsive committee is deemed to have refused your request. That is the trigger to dispute the reasonableness of that refusal, because that's effectively what it is at that point, a refusal. Yep. So that's a huge difference.
It is. It's a massive difference, and it's also the just the practice of, you know, which you've been able to do in a sense of saying to particularly, I suppose, Chris, vexatious owners.
Well,
challenging owners.
I was just about to say, I noticed a query on that very topic from John. John, nice to see you tuning in, asking if there's any additional protections for committee. I actually think that this provision is a way in which the government is offering committees a bit of protection and a bit of safeguards against, let's call them challenging individuals, Frank, challenging owners who bombard the committee with endless, voluminous requests. Under these provisions, effectively, those owners are going to be extremely limited in the number of motions that they can put up in any period of time. So I think this is a step towards finding a way to dealing with challenging owners.
Yes, I suppose. Go the old Western example. You've got 6 bullets in your gun. Once they're fired, gone.
So what does this mean? Like, for owners, you're going to have to be really strategic about what it is that you are seeking. And I've got to be honest, Frank, I think if you cannot deal with your issues with 6 motions in 12 months, I'd say that was a bit extraordinary, frankly. There might be some circumstances, there might be some really desperate circumstances where you would have more than 6 motions in 12 months. But there are other ways to deal with exceptional circumstances.
Oh, and dare I say it, I'm sitting here just running over my mind, how would I deal with that? Acting for a lot owner is you get in concert with 2 or 3 other people and you've got 18 motions in 12 months.
There you go. Yep. But I think the onus is very much on owners to make sure they are being strategic, but also complying with this section. The onus is on committees, though. They can no longer either apathetically or vindictively not make a decision. They've got to do something.
And they must explain that decision, which, you know,
Yep.
for me, acting reasonably is explaining why you said no, or why you've refused it, or why you've ignored it. So now there's actually a statutory obligation to do so.
Yep.
So, and one of the things that does cause all these fights is just complete radio silence. You know, people jump at shadows and they're ignoring me, and it might be personal. And yeah, so it sort of, again, raises the bar a little bit in terms of what committee members are going to be required to do.
We've got a bunch of questions about that one, Frank. So just to try and cover off some of those, that's 6 motions for an owner in a 12-month period. That is distinct from a Form 12. That is distinct from correspondence. And please remember, a motion is not correspondence. Correspondence is not a motion. A motion is where you are asking the committee to decide upon something. I want approval for my pet. I think the pet one is a great example to use here, Frank. So now, if you are moving into a community title scheme and you want your animal, you know that there might be up to 6 weeks with a possible additional 6 weeks for the committee to decide upon your animal. So you need to start taking that into account. Now, there are obviously exceptions for emergency circumstances and urgent circumstances and all that sort of thing, but it remains the fact that you have 6 motions in 12 months. It does not include Form 12s. It does not include correspondence.
And I suppose it still doesn't authorise in a sense of, I'm settling my unit tomorrow. I want the committee to make a decision on my pet today. It's like, well, they've got 6 weeks. The Act sets 6 weeks. So there's the statutory standard.
A couple of clarifying points there. If the motions submitted by the owner are a restricted issue for the committee must decide against them. If those motions are effectively motions that would be ruled out of order at a general meeting, then the committee must also decide against them. Yeah. That's obviously one that's caught a lot of people's attention, judging.
Well, including ours when we were running through this. It's like, wow, look at that. Yeah. So look, there will be Commissioner's Office decisions about that without any doubt at all.
I just want to pick up a point there from Yana. Yana, thanks for tuning in. Can the committee simply resolve no without explanation? No, they can't, because that's unreasonable. That's precisely where unreasonable decision-making kicks in. The next one, Frank, a bit of a strange one. I'm not really sure why it's there. Removal of committee. I'm not even sure why we're talking about it, but anyway, let's talk about it.
Oh, like, to me, I mean, how many times have we had conversations about removing people as committee members for breach of code of conduct when there has always been the mechanism there to remove committee members by ordinary resolution at general meeting without cause? So I think probably the way, this to me is a direct response to having 2 separate sections for removal, and people go to the code of conduct one first, when the reality is it's a hell of a lot easier to simply have a general meeting resolution, more votes for than against, committee member removed, all over Red Rover. So the code of conduct remains, I suppose, what would you call an aspirational type thing. It doesn't really have much teeth in the sense of enforcement, because what it was really going to be used for was removing committee members, and the process of going through it. I've never done it, because every time we have clients approach us about doing that with respect to a committee member, the response always is just go ordinary resolution. If you're going to get a breach notice issued under the code of conduct at general meeting, you've got the votes for that, then ordinary resolution will do just fine, and you don't have to prove anything.
Absolutely, yeah. So, I mean, the way in which this has been framed is that the government has said this clarifies the process for removal. It's a bit of a subtle one, that one, but if it does clarify and it does actually reinforce to people what the options are, then I guess that's a good thing. But yeah. Next one, about a lot owner's representative attending a committee meeting. So we're still in the committee category here, everyone. So everything we're talking about at the moment relates to committee meetings, not general meetings. Please bear that in mind. So at the moment, there's no provision for a representative of a lot owner to attend, but there will be now, Frank, won't there?
There will, a representative, and not any particular basis, not necessarily a power of attorney, not a proxy, not a friend, not even a lawyer. It's basically the same 24 hours notice is given along with the evidence of the appointment of the representative. So Chris owns the lot. I want Frank to go to the committee meeting. Chris wants to go to the committee meeting. I send a letter to the body corporate manager saying, hey, I'm going to be there representing Chris. Here's my authority to do so, which is a letter from Chris saying, Frank can go and be there. Bang, I'm there.
That's right.
So it used to be a little bit, I suppose, tightened up in terms of actual lot owners. Now it's, I suppose, Chris, almost support people.
Well, Frank, you and I had a read of this before, didn't we? And we thought that this now enables a lot owner to advocate for a support person to come with them to a committee meeting. There's a separate question about why people would want that, given the process for attending a committee meeting anyway. But I think that these provisions do actually open up that possibility. So I think what it does, it formalises something that might have happened a bit informally up to this point. Or there might have been confusion about it. That's how I would tend to view it anyway. The next one I think will be pretty popular with most people, although who knows really. So at the moment, this may shock a few people watching, but if you're a committee member, you can still vote, even if you owe a body corporate debt. That's changing, Frank, isn't it?
It is. It is. It is. So it's been one of the bones of contention for a while as people are, so I suppose, where the legislation has tried to get to is encouraging people to self-nominate. So Frank nominates Frank for committee. So that way I'm in control of what's going on and et cetera, et cetera. There is the ability for Frank to nominate Chris to be on the committee and vote away. And one of the constant quibbles has been, but you've got to be financial at the time you nominate, both the person nominating and the nominator, and also at the time of the meeting. But for that next 12-month period, there's no obligation to pay your levies at all. So what the legislation has, or the modules have created, is a new phrase called a debtor, put that in the phrase, debtor member, not quite debtor's prison, I think, which was the 1600s in England, as much as somebody's corporates probably would want that. Whereas if the person or the committee member is unfinancial, or the person nominating them is unfinancial, they don't have a vote. So it's going to be really interesting from a, I suppose, strata management perspective, and this probably falls back to the body corporate managers, because it certainly won't be within the scope and knowledge of the committee members. If Chris has nominated me to be on the committee, I don't know whether he's paid his levies. I'm going to continue to go and vote and do all my committee member functions because I feel like it, and it'll be up to someone to make sure that Chris continues to pay his levies, as do I, through that period of committee tenure.
Yep. I agree, Frank. This will, I think, focus committees and strata managers' attention on the financial management, and also just exercising a bit more of an eagle eye over body corporate debts, which is precisely, I think, what the legislation would always want to have happen. That's certainly the intention of the legislation. This is one method by which I think it will happen. It will probably place a lot of obligation, and that's going to be tricky. Frank and I have already had some colourful feedback from one body corporate manager about it. I dare say there will be others, but there you go.
And you'd like to think that could be a software solution for strata management companies with their software providers, because if you tick a box who nominated, make sure their financial checks before, but I'm not a software creator or manager, but I think that would be the best way to do it, because doing it manually every time would drive you nuts.
I reckon so too. Our final new provision in the committee section is about what's called a VOC, a vote outside committee meeting. As it currently stands, there's no time frame in which there needs to be a response, but under the new provisions, there will be a 21-day time frame and provision for what is deemed to have passed. Frank, do you want to expand upon that?
Yeah, and effectively this is back to that apathy type thing. So VOCs at committee level are purely majority. No one's got special votes. So committee of 6, 3 all, not passed. Committee of 6, 4-2 in favour, 4 in favour, 2 against, it's passed. But up until now, there hasn't been any, I suppose, drop dead date. So again, we're back to this deemed refusal type thing, is if something's not passed within 21 days, it's deemed to be refused. So it's so at that stage, then that is also then the trigger for what could potentially be a commission's application. But the committee has said no, and the act or the module actually creates that refusal by virtue of the fact it hasn't been approved within those 21 days. So it probably just closes the loop a little bit on stuff just drifting off forever, which tends to happen.
Agreed. So I think that's the committee stuff. We're going to move on now to general meetings. So again, just to clarify, it's always worth making this clarification, I think, Frank. Committees are the smaller subset of all owners, but when we talk about general meetings, that's all owners at a general meeting, be it an annual general meeting or an extraordinary general meeting, who are financial and therefore entitled to vote. And that's where most of the big ticket decision making gets done. So the first one we're going to talk about is what's called the first annual general meeting. So at that first annual general meeting, there is nothing that necessarily needs to be done or decided upon. But Frank, there's going to be a difference now, isn't there?
There is. So the way, I suppose, buildings or meetings come into existence, and I suppose, Chris, we should talk about electronic voting too.
Yeah.
I suppose we sort of just assumed that, so the way, the life cycle of a building, it is a dream by a developer, sold off the plan with lots of disclosure documents and contracts, thing gets built, and once the plan actually registers, so until the plan subdividing the land into individual lots registers, it's just a block of dirt. The moment that plan registers, a body corporate comes into existence as of law, and that body corporate is then owned, all of the lots in that body corporate are owned by the developer. So there's a period of time there where the developer owns all of the lots, and at that stage, they vote through at the first EGM of the body corporate all of the arrangements that have been disclosed to buyers off the plan. CMS bylaws, management rights agreements, administration agreements, et cetera, et cetera, et cetera. There's then a statutory obligation to have a first AGM, I think within then again, there's a timing issue with this, but very quickly after that, there needs to be a first AGM. So what happens is developer votes, creates that body corporate, enters into the agreements. The owners then start settling the purchase of their lots, so they become lot owners. So very quickly, the voting control changes going that way, back to the owners. And usually the agenda for the first EGM, is very static. The first AGM is usually pretty static. It's just a bunch of statutory motions because at that stage, no one really has expressed an interest. And they've specifically changed the module to allow owners who've submitted motions to go on the agenda for that first AGM, which from a body corporate management practice, from my perspective, would be exceedingly unusual to date. So if someone settles the purchase of their unit and the next day fires in 15 motions to the body corporate manager to say, this is what I want to be considered, then that's got to go on the agenda for that first AGM, as opposed to the second one, which will be in 12 and a bit months' time. So that's a change. So, and I suppose it's losing the excitement, everyone's moving in, et cetera, et cetera. I don't know where people's attention will be focused, but that is definitely different from what the practice is at the moment.
It's one of several changes, isn't it, Frank, for new buildings under this regulation module, which we'll get to a bit later on. The next one was another little surprise which came to us. One of the more vexed issues that occurs at the general meeting is the issue of a motion with alternatives. So in a nutshell, that's when you have one or more motions that are more or less on the same topic. The legislation currently demands that they be grouped together and decided effectively together. That of itself is not changing, but the terminology certainly is, Frank, isn't it? As is the way it gets decided.
It's now a same issue motion. So previously what had to happen, and there was definitely some disputes about this in the Commissioner's office, and these things get done wrong a lot, is what I would say. Because what happens is, again, Chris fires in a motion, I fire in a motion. Someone needs to check them and make sure that they aren't the same issue. And at the moment, and I suppose for the next 6 months, they need to be structured. So let's hypothesize. What we want to do is engage someone to give our body corporate advice. So it's a choice of Chris or a choice of Frank. So someone fires in Chris. I know. I'll back you in every time, mate. Someone fires in Chris, someone fires in Frank. So the way the motion would have to be structured at the moment would be sort of effectively above the line and below the line. Above the line is that the body corporate engage someone to give it advice, yes or no. And then part B of that would be, assuming that the threshold is passed, so there's more votes for than against of above the line. Below the line, option A, Chris, option B, Frank. And only the people that voted yes above the line then get to make a decision below the line in terms of which one they choose. And so, in effect, you might have at the moment a motion, if we've got 20 votes, we've got 11 votes in favour above the line and 9 against. So obviously we've got some people that don't like us, Chris. And then below the line, it's 6-5. So Chris wins by 6 votes out of the 20 people that cast the vote. And that's the way an alternative motion, which is the current wording, is decided. So this change was also different to what we'd seen. And there's some, I suppose, it is complicated. It will remain complicated. And I think what's really important is for people to make sure that they do assess the style of motions that are coming in, because if there are more than one submission coming in relation to a particular issue, then it definitely is going to be contested and topical.
That's it, isn't it, Frank? If we come back to your scenario, advice from Chris, advice from Frank, there would be no need to even talk about this if everyone was unanimously agreed that it was going to be Frank that was providing the advice. But there's clearly a difference of opinion, and particularly if there's like several of them, that's clearly a very divided set of thinking that's going on. So that, as you quite rightly point out, it's contentious. There are big differences of opinion about which way people want to go. It usually means the spending of a lot of money. So that's why it's contentious. That's why the provisions are quite detailed. If you have a look, it's section 89 of the new standard module. It's pretty detailed what is set out there about how the calculations will be done. I think, you know, Frank and I would definitely be of the view that bodies corporate that find themselves in a position where they are not 100% clear on how to present or group motions or how they should be tallied at a meeting should be seeking some advice on that sort of thing, because I can guarantee you it will be disputed after the event.
Because someone's going to lose. And I suppose what the big change for me is they're getting rid of the above the line, below the line. So where the new motion would be structured is that the body corporate engage Frank as a Strata advisor or Chris as a Strata advisor, and you can vote yes or no to all of those. So you can tick yes to both if you want, and then it drills down into how the alternative motions are actually decided. So if, for example, Chris and I both had 6 votes each in favour, the way that's not then the toss of a coin just yet, because they look at the votes against. So if there's actually 5 votes against Frank and only 3 votes against Chris, then Chris gets the gig because there's less people that dislike him than dislike me.
And of course, the really fun part, Frank, is the situation where there's a tie. And when there's a tie, it's decided by chance, flip of a coin.
Yep.
Can you believe that we've got millions and millions and millions of dollars at stake potentially in some of these motions? It will literally come down to the toss of a coin in some cases.
I actually have drawn straws. I did a general meeting once in above a bar area, and it was basically the last vote was for a committee position. The last position had 3 people that tied. We went downstairs, got a straw, cut it into 1 long length, 2 short lengths, and the person who drew the long straw got the gig. It's very funny.
That is fantastic.
Yeah.
Welcome to body corporate legislation, Queensland style. Look, we could spend all day, literally, I think, talking about the new same issue motion provisions, but we need to move on. But I think that might be its own webinar at some point leading up to March, I suspect, Frank. So stay tuned on that one, everyone.
There'll definitely be more content we'll be producing about this stuff. It just arrived yesterday, hot off the press. There'll obviously be, a lot more thought put into it and detail. Because there's a lot in it.
An interesting one that's turned up. At the moment, there is no express provision that the agenda must be approved by the committee.
Why would that be an issue, Chris?
Well, Frank, in my former life as commissioner, I heard quite a few times allegations by committees and owners that the agenda had been prepared and put forward by a body corporate manager. I don't know how true that is or how often that is, or if that's accurate, but I certainly heard it enough to know that it might happen at least once or twice. So under the new regulations, there is an obligation on the committee to prepare the agenda. That is distinct from the committee approving the agenda. Do you think there's much of a difference there, Frank?
Yep. So You know, it's one of those things where motions do sometimes appear that they might not otherwise appear. So it's interesting one that. I don't think that's necessarily cured what the original intent might have been. So that will be an ongoing issue. So I suppose from a committee perspective, it's just a matter of making sure that you're in control of what goes on your agenda if you want to be that tight about it.
Yep.
You know?
Definitely.
Simple.
Let's talk about quorums briefly then, Frank. So just to clarify, a quorum
What
at
a
the moment,
wonderful word.
yes, it's a fantastic word. Quorum, in a nutshell, is the minimum number required to legitimise decision making, and that applies not just in the body corporate context, across a variety of contexts. Anybody who's ever been involved in body corporate stuff would know that quorum counting can be very, very tricky, and it is also one of the most disputed about things in the Commissioner's office because there are so many variables involved. The new regulation modules, I don't think change those variables so much, but interestingly, they throw back to the body corporate the ability to decide the actual quorum number, Frank.
So, and I think probably for me, the issues with quorum more than anything else at general meeting level particularly is it's the number of voters, not the number of lot owners, because those are two completely different things. So if I own 15 lots in a building, I'm one voter. So when you get into counting quorums, and at the moment it's really 25% of, 25% of voters, will leave it at that for the moment. That can represent a substantial number of the lots in the scheme, or obviously just straight 25% or otherwise. So what the legislation is now allowing is a body corporate to make a decision to reduce the quorum to effectively 10%, or between no less than 10% and create an obligation no more than 25, which is where the standard is at the moment. So a body corporate may decide that our quorum is now 12% of voters. So, and I suppose the consequence for there not being a quorum at general meeting level purely is that the meeting's held over to the same time, same place next week, and whatever's there on the day is then what's counted. So in effect, it gives people the ability to have another week to exercise their voting rights. So we will talk about electronic voting in a minute, which is basically going to be allowed. So I think probably one of the issues that has definitely happened since the first version of the modules in 1997. We didn't have iPhones then, we didn't have emails the way we did, we didn't have prospects for electronic voting or anything like that. Now we do. So the ability for people to participate in decision making is a hell of a lot easier when you can press yes or no on a mobile phone app than have to physically get something in the post and put it back in the post, because the other thing that's slowed down a little bit is Australia Post delivery times. So yeah, it's an interesting one. Probably, I don't think, well, I'll put my head up and say I haven't really thought about what would be the rationale for reducing it, other than potentially, I suppose, lessening the risk of general meetings being adjourned because you're more likely to get the right number of voters to have the decisions cast on the day.
If you've got a body corporate that historically has struggled to get a quorum, but gets close, that might be a circumstance where reducing it might actually be in its favour. I want to talk about powers of attorney. So bear in mind, we're talking about powers of attorney here, very, very distinct from a proxy or being a representative or a corporate nominee. Power of attorney is a very distinct thing. At the moment, under body corporate legislation, there is no restriction on the number of powers of attorney that a person can hold. That's going to change, isn't it, Frank?
It is. It is. And I'm going to say I'm the cause for this, but there you go. So I have been to various general meetings with lots of powers of attorney over recent months and years, and they're now restricting powers of attorney effectively to just be members of the donors or the giver of the attorney's family. So that has gone away. I suspect there's another little loophole there that I haven't really discussed with you, Chris, but I'll do that later. But yeah, so effectively, so Bugta, we spoke about Bugta very early. Bugta, they still have proxy farming and proxies and all that sort of stuff. Proxies under BCCM are very limited in terms of numbers and actually even what you can use them for. There was no such limitation on power of attorney, which has been tightened up substantially.
That's right. So between now and March next year, you can go nuts with proxies. From April next year, it all changes. bear that in mind.
Bom.
And then one final one. At the moment, there's been no need to explain why motions were ruled out of order in the minutes.
In the minutes.
Yeah, and that's now going to change. And I think, Frank, our view on that one is if that's going to happen well and good, it might be a good idea to get some legal advice to summarise that.
Yeah, so there's a very strict, I suppose, structured process about what happens if a chairperson does want to rule a motion out of order at a general meeting, must explain why, must invite the meeting to overturn that decision. But up until now, the minutes would simply say motion ruled out of order without as to why. So again, it's very subjective, but attaching a formal little legal statement as to why, because inevitably knocking something on the head that someone's put in is an invitation for a dispute.
Absolutely.
So making sure you've got the right basis to do it is really important.
We'll move on to insurance now. So the new regulation modules cover a few issues relating to insurance. Crucially, they do not cover a couple of the critical issues to do with insurance, which we'll get to in a second. But three...
I suppose, and this was...
Yeah.
Yeah.
Go, Frank. Yeah. No, go ahead, Frank.
I was going to say, mate, near and dear to your heart in the context of North Queensland and the insurance difficulties that, well, clients are continually having up there.
Yeah. So what the two of the changes relate to disclosure. So the first one is that at the moment there's a need to disclose a commission, but that could be in simply percentage terms. Now the commission needs to be expressed as a dollar amount, and before the contract is entered into.
Yep.
It's a big,
so
it's a significant change, Frank, isn't
it? It is, because there is a massive difference between my commission's going to be 10% and my commission's going to be 15,000. Is the reality of it. So yeah, so I think that is actually putting a dollar amount on things is, I suppose, more transparency from government in relation to how that is being done. And I think probably from and we had a dispute on this that we did win, but they've actually also made a committee renewal of an insurance policy. It'll put in place insurance that's above the spending limit, not a restricted issue for the purposes of getting that in place, which is important because, I mean, one of the key things, and this is why insurers, I suppose, have a field day in the sense of everybody corporate in Queensland must be insured for certain things, no choice. So we can choose to insure, not to insure our own houses, cars, lives, or otherwise, but bodies corporates don't have a choice. So it's a very captive market in that sense. So giving committees the ability to be a little bit more flexible about that does make a heap of sense. And the other one, I suppose, is really from a disclosure perspective, is disclosing details of brokers or intermediaries who are involved in placement of insurance. So they're just the level of transparency and disclosure is rising in that particular place. But I suppose, mate, you'd know better than I do, it doesn't actually cure the key issue, which is how do we actually get insurance for buildings?
And how do we afford it if it goes up 300% every year?
Yep.
Which I know for anybody watching this who's in North Queensland, I know that happens and is happening. Look, I won't belabor the point too much, but we're involved in a couple of insurance-related matters for clients at the moment, so happy to have that discussion with anyone. I also know that politically there's a bit of work going on around body corporate insurance, particularly in North Queensland. Watch this space is all I can say. Administrative issues, and I know that doesn't sound particularly sexy, but there's actually some reasonably significant changes here, Frank, most notably around sending notices electronically.
Yes. Yep. So it's an opt-in system now. So, and I suppose where the Commissioner's Office has absolutely got to, and adjudicators have been authorising, in effect, notices given electronically, even though the legislation didn't, you'd say, necessarily specifically allow it. Now it specifically allows it, and it's an opt-in system. So it's not going to happen automatically. The way the legislation is actually worded, that an agreement must exist for notices to be given electronically. So that's effectively, for a better phrase, an owner ticking a box to say, yes, please send me these things by email, in which case they can all then go via email. So that will be, well, a hell of a lot better for everyone in terms of communication.
Absolutely. So yeah, I think that's a really straightforward but good, and it formalises what's been really happening in that situation. The next one, the eternal struggle between the secretary and the body corporate manager, and the difference between the two things. So Frank, at the risk of triggering some of our viewers, very briefly, do you want to explain what happened here?
Okay. It's a building called Whitsunday Waters, very contested decision that probably was just causing a massive kerfuffle before COVID arrived and everyone got some perspective on it. And the issue really was that owners returned some votes to the body corporate manager for a general meeting. And when you looked at the strict wording of the legislation, those votes should have gone back to the secretary. The act, the module said secretary. It was on a special resolution. 2 votes that went back to the body corporate manager were tossed out because they went to the BC at body corporate manager direct, which meant the special resolution was then lost. So the new module basically says, not basically says, it does say that if something can be given to the secretary, it can be given to the body corporate manager, provided it's within the terms of their engagement. So if a body corporate manager's got the ability to receive notices on behalf of the body corporate and act as the secretary or act with the secretary's instructions, all that sort of thing, knocks that on the head. So that Whitsunday Waters decision has been dealt with. But I think there's still, yeah, and this is one of the things, again, that appeared in a from excuse me, legislative perspective, that's really interesting. So when you go to, because we now can have electronic votes for committees, for general meetings, for secret ballots, and all sorts of things. So, and there's specific sections there about the requirements for conduct of secret ballots and specific ones. So if you want to be really detailed about it and go to section 25, it's an interesting one where if a body corporate's decided that the voting on committee members will be decided by secret ballot, there's a specific section of the Act or the module that now says, excuse me, all votes cast before the AGM ends are to be in the custody of the secretary. Now that's secret ballots. So I'm assuming that there will be, well, I suppose in the secret ballot requirements are that the technology platform, so where the regulations got to, it hasn't mandated a particular style of user or program or anything like that. What it says is that for a secret ballot, the identity of the voter must be protected and that the system must be able to work so that it can discount people that are unfinancial and make sure there aren't votes counted twice and so on. So that's all fairly vanilla. But the interesting thing that got me is it's all votes cast before the AGM ends are to be in the custody of the secretary for a secret ballot. So is that the body corporate manager or not? Or is it just the secretary? And the other thing is that when you look at the way secret ballots are cast now physically to a returning officer, the way it works, particularly if you're going to go, say, pluck a figure, AGM, management rights variation, you fill in your ballot paper, yes or no. You put it inside an envelope and say on the back, Frank Higginson, lot 1. Then you put it inside another envelope and post it back to the returning officer. So when the returning officer gets it, he or she can see, well, it's come from Frank Higginson, lot 1. Yes, he's financial, opens that up. Then the inside ballot paper that doesn't have my details on it goes into a little box. All of that's done, then they open them up and then there's no identifying marks on any of the votes and all that sort of stuff. So no one knows which way I've particularly voted. And the technology piece here, which is really interesting for me, when the first thing I thought when I read this was if all of the votes have to go back to the secretary, is the secretary allowed to see them before the meeting and throughout the process? And probably not would be the intent, but I can't see the statutory prohibition on that. So if Chris is the secretary, and I've nominated against him because he's a complete tyrant, and Chris keeps an eye on what's going on through that process and starts without knowing which way people have voted, but knows he's going to go down in the vote. Is he out there lobbying like crazy to get everyone on board?
Yep.
Anyway, this is the sort of stuff that's not quite final, that probably will be the source of contention at some stage, because I look at that and it's just like, wow.
Absolutely. There will be more on that one. There will be more on that one, I suspect. 2 very quick ones in relation to the role, which I'll address now. So as it currently stands, there are 2 months timeframe in which to provide information to the body corporate to update the role. That's now been reduced to 1 month. A couple of points I'd make about that. Number one, still the onus remains on the body corporate to be vigilant and proactive about the role. The role is one of the most vital tools the body corporate has in anything that it does. So they need to be proactive about making sure it is up to date, essential. While this puts an onus on people to provide information more quickly, it doesn't take away the need for the committee, body corporate, to be vigilant about getting those details up to date. Second thing to note, interestingly, there is a 20 penalty unit penalty if you don't provide your information within 1 month to change the role. That equates to a fine of just a tad under $3,000 if you want to pursue it. So I don't think that's a small amount in the grand scheme of things. I reckon bear that in mind. And the second thing to do for the role, there is no time frame for the body corporate to update the role after it receives info. There is now a requirement to do so within 14 days of receiving. So again, that onus back on the body corporate and the body corporate manager to be really vigilant about the role. Again, I can't emphasize enough just how vital the role is in the day-to-day operations of the body corporate. It governs everything, basically.
But
We're
it's
almost
still
at
public
the,
too, isn't it?
It is still public.
Not public, I mean public to other owners inside the building.
Yep. And Catherine, thanks for tuning in today. I know you've had a couple of questions there about the role. No changes to what is provided, and certainly no changes around privacy. Body corporate roles are not subject to privacy legislation. Yeah. And then finally, we're almost at the end, but very quickly, we're going to cover the situation with new buildings. We touched upon that a bit earlier, but just a couple, these are brand new provisions which had not been in the reg modules previously. Frank, do you just want to really quickly cover off those two?
Yeah, absolutely. So the developer has an obligation to hand over at the moment certain things to the body corporate when they register a building, because the body corporate in effect is novated into the shoes of the developer and can exercise whatever rights the developer could have with respect to the contracts that the developer has caused the body corporate to enter into. So that is things like construction and so on. So what's happened, and this is section 96, I suppose I don't need to run through all of them now, but there's a bucket load more detail that the developer has a statutory obligation to hand over to the body corporate at the first AGM. And interestingly enough, the penalty there, Chris, is 150 penalty units, which is a substantial amount of money. So it is, so sinking funds, proxies, powers of attorneys, contracts for work, plans, utility services, warranty documents, valuations for units, fire and evacuation plans if needed, just basically everything that good practice would dictate, but wasn't necessarily there. So that is a lot more comprehensive than ever has been.
And interestingly, Frank, while that obligation is now there, it still means effectively legal proceedings to get it out of the developer if they don't cough it up. I think the crucial point here is that you cannot go to the Commissioner's office and seek an order for the non-provision of information from a developer yet, anyway. That is certainly on the cards.
That was one of the discussion papers, because that's in the Act in terms of the jurisdiction of the Commissioner's office to be able to make orders in relation to certain things.
Yeah. And crucially, just very quickly on the topic of new buildings, one of the other things is that at the second AGM, that will need to contain a motion proposing the engagement of what's called a suitably qualified person to prepare a defect assessment. And that's what's called a defect assessment motion. So in another way of putting it, at the second AGM, the body corporate has to turn its mind to building defects, whether it wants to or not. Of course, that raises an entirely separate issue about what happens if that motion is on the agenda and doesn't get up. That's another issue again. But
is that a reasonable decision?
Yeah, exactly.
Yep.
We have almost reached the end today. Gosh, we did well there, Frank, getting into that time frame.
You are a timing machine.
I am. Look, I think it's fair to say we have not scratched the surface, really, on today. Looking at some of the questions that have come through, and I'm sorry, we just could not possibly get to all of those questions today, everyone. But there are clearly some issues there that we would like to have answered. We did not get the time. We may be able to get to some of those questions on Facebook in the coming days. We may not necessarily be able to do that, though. What I would say to you, if you've got a burning issue that you think that we can assist with, please email us at the address that's scrolling on the bottom of the screen. A couple of sum up points out of today. First of all, this will not be the only info that we put out about the new reg modules, far from it. So please make sure that you like and share our social media and are subscribed, because that's how you'll find out about these webinars and other things to help keep you informed. I said at the start, there's going to be plenty of instances where some of this will not be clear. You have to revert to best practice. Best practice means being methodical, it means due process, it means making reasonable decisions. One of the best ways that I describe to people what a reasonable decision is, put yourself in the shoes of the other person, or try and put yourself in the shoes of the other person and see how they would like or not like that decision. There is always a defense against inadvertent error. But again, you need to have shown that you've done everything to try and avoid that if you can. The other thing I would add is that we talked about amendments to the Act and how they haven't been contemplated. There is still also floating around the potential for some COVID-related regulation amendments. We haven't actually seen those at this point. They may yet occur before the end of the year, and they will be, if they happen, to do with financial management and financial arrangements. Which reminds me, we haven't actually put up the link to the legislation. How about we do that right now?
And what I would say, mate, I think there's quite a few Strata managers that are online that have been answering people's questions for us as we go. So thank you everyone for participating in that. It is appreciated.
Definitely. And I guess the thing is, look, body corporate managers, you are in a tough position. We'd like to think that we know most of you, have met most of you, have a good relationship with most of you, but you please come back to us if you think there is something here that we can assist with in particular. But I guess, Frank, the point, and I'll bring back Nikki at this time. I think the point to make there is that this is far from the end of discussion about this. There is a long way to go in terms of implementation, in terms of prep, but if anyone thought that 6 months was a really generous time frame to prepare, I think today's discussion would leave you in no doubt that you're going to need every one of those 6 months to make sure that you're in the best position.
Agree.
Right.
Agree.
With that,
yeah. Thank you, Nikki, for co-promoting and continuing our long relationship with you. It's always good. And thank you, everyone, I suppose, for coming along in the feedback and the participation today, which has been great. Obviously, it's a sensational topic. I sound like a lawyer there, don't I? It's a really interesting topic, and there's a lot more to come on it.
And we've had really great involvement today from everybody being part of this. So really appreciate it. Don't forget to like and share. Thanks, Nikki. Thanks, Frank. Thanks everyone.
Very much.
See you.